Hi, it's kctvmedia.com here, and I want to thank everybody who has sent links to us that now we've been able to really bring together a lot of information for people, young and old, who have always doubted joining the Europe thing, European Union. And I have a particular video which was given to me by a dear woman who said, I've had this for 20 odd years, you need to look at it, and we've done our utmost to record it and re-edit where we have to, so that you can see 51 minutes of evidence really of what they've been trying to do to Britain and have almost succeeded. But if we are able to tell other people and share this information, please, then we have a chance of coming out with a resounding vote leave. Okay, now this video is called Britain and the European Union, the Facts. Amazing. It is amazing because I look back and think of how this started. We had no campaign. Well, the campaign has gone viral and people are sharing this information. They're sharing off the website at kctvmedia.com this particular little heading, which is Britain on the brink. Please click and go inside and look at the wealth of the information why this country will not link up with Europe, trade with Europe, but not to go any further. And this chap called Trevor Coleman, who provides the facts, Britain and the European Union, covers all points. And I'm not saying he's perfect. He's got himself into a little bit of bother apparently, but that's the way it goes. But the information that he has declared and shared here should help you, your family, and everybody in Britain realize what Europe is about. Okay. Thank you for listening. Now I expect you to watch this video. The quality is not brilliant because we've had to do this late at night and we've had to do it quickly, but this is the last content that I'm putting up on Britain on the brink, and the title of this information is Britain and the European Union, the Facts. This was recorded over 20 years ago, apparently. Thank you for all your help. Bye for now. God bless.
Good morning, ladies and gentlemen. Thank you very much for allowing me to come here today to talk on this topic, Britain and the EU. Before I start on the presentation, can I just say a number of things to explain what I'm not here to do. I don't intend to mention any political parties at all during this discussion, unless you ask me to, other than to identify those politicians who negotiated or signed treaties. Neither will I express any opinions or draw any conclusions. The main purpose of the talk today is for me to pass as much information as I can to you about the European Union, so that you can then make up your mind as to whether this is a good or bad thing to belong to. So, what does it mean being members of the European Union to us in Britain? It means that we, the British, no longer have control over our fishing, our farming, our courts, the making of legislation in this country, our citizenship, and the ability by our own government to give aid to its citizens. Further, we are losing control of these areas of our life: our police, our system of justice, our armed forces and our taxes, our currency and our transport systems. Soon, Our financial services and the stock market will no longer be in our control. And for the first time since the Second World War, and not because of the recent foot and mouth disease, we have lost the ability as a nation to feed ourselves. And perhaps more important, we're about to lose control of the selection of those who govern us. In addition to all this, we will soon lose control of these areas of our life. Our postal service will soon be totally different. Our art market will soon be gone. The right to free speech and free association is rapidly going, as is our identity as a sovereign, independent country. And soon, we will lose our own government in this country. All this because we are members of the European Union. How did this all come about? How is it that after centuries of an independent, self-governing existence, we find ourselves in this position today? Well, we signed a number of treaties, 5 in all. And the whole thing started way back for us in 1972, when the then Prime Minister, Edward Heath, negotiated our entry into the then common market by signing the Treaty of Rome, which was the first of the 5 treaties. In 1975, a referendum was held in this country when the electorate were asked to decide whether or not we should remain in the then common market. 60-odd% said, let's stay in, and 30-odd% said, let's come out. And so we stayed in the common market. What we didn't know at the time, of course, was that we hadn't been given the true picture about exactly what it was that we joined. Papers have been released under the 30-year rule, which now show us that we were being told things that weren't the whole story. Let me give you some examples of what I mean. We now know that Edward Heath used the Information and Research Department of the Foreign Office to promote only favourable stories about the common market. There were a number of things that they did. We know that that department used the Today programme, The World at 1, ITN News and News at 10 to promote only favourable stories about the EU. A popular presenter at that time objected to the use of the medium and subsequently was sacked overnight. His name is Jack DiManio, and he was never heard on the airwaves again. We also know that a number of documents and reports were suppressed at that time, and they've now been released under the 30-year rule. I'll read you just a couple. Pierre Werner, the Prime Minister of Luxembourg, produced a report in January 71 where he said, and I quote, "The long-term objectives of EMU are very far-reaching indeed, and the degree of freedom vested in national governments might be less than the autonomy enjoyed by the states of the USA." And also, a Foreign Office memo at that time states this: "The common market is a process of fundamental political importance, implying progressive development towards a political union." Whilst all these documents were being suppressed, we were being told in this country that we were joining a trading partnership. And it was on that basis that the people in the referendum voted as they did. That was the knowledge they had at the time. Whilst these reports were being suppressed at the time, a number of other documents were being produced which were of a pro-European nature. The main document, of course, was the pamphlet that was issued by the Harold Wilson government leading up to the 1975 referendum. I'd like now to read just a couple of quotes from that, where the Wilson government were reassuring the public about the future life in the common market. Here's just the first one. The document says, and I quote, "There was a threat to employment in Britain from the movement in the common market towards an economic and monetary union. That is a single currency." The document goes on to say, "This threat has been removed." Wilson is saying there that there was no likelihood that we would be asked to join a single currency. And the second quote, later on in the pamphlet, says this: "The minister representing Britain can veto any proposal for a new law or a new tax if he considers it to be against British interests." Wilson there is talking about the national veto and our ability to stop anything that is disadvantageous to the British, the national veto. We will see in a moment whether or not the assurances given by those two quotes have been maintained to this day. While this was going on, there were other quotes that were coming out of Parliament, again, that reassured us. Again, I will give you just a few. In 1971, in a government white paper, Edward Heath said this, quote, "There is no question of Britain losing essential national sovereignty." And he went on to say this, "The British safeguards of habeas corpus and trial by jury will remain intact. So will the principle that a man is innocent until he has been proved guilty." And again, we will see today whether or not those quotes were truthful. And finally, a quote from the Lord Chancellor himself, at that time Lord Hailsham, and he said this about the European Communities Bill, which was the bill that took us, the British, into the common market. He said this, "It is abundantly obvious, not merely that this bill does nothing to qualify the sovereignty of Parliament, but that it could not do so." He is saying there that the sovereignty of Parliament is safe, even if we enter the common market. And again, we will see whether or not this assurance was founded on fact. Reassured by these statements from our own politicians, the British public voted to remain in the then common market. 30 years down the road, this is now what governs this country. This is a graphic of the governmental structure of the European Union. Compare it, if you will, with this simplified graphic of the House of Commons, which was our supreme governing body until recently. Let us look briefly at the structures that make up the European Union governmental structure. First of all, there is the presidency. There is no significance to this particular post. There are 15 nation states in the European Union, and every 6 months the presidency is handed around from one nation state to another. It is purely symbolic. Having said that, when each of the nation states holds the presidency, it likes to be remembered for an initiative. The French, who held the presidency at the end of 2000, will be remembered for the Treaty of Nice. That's the presidency. Below that comes the European Council. This is one of the 3 powerful forums that control the European Union. The people who attend the European Council are the 15 heads of the nation states. They are accompanied by their foreign secretaries or their foreign equivalents. The President of the European Union attends, as does one other commissioner. This council meets twice a year. Let me read you what the purpose of the council is. It is to establish policy guidelines for European integration. Even though the member states defend their interests in the council, they are at the same time obliged to take into account the objectives and needs of the community. The council is a community institution, and it is not an intergovernmental conference. One other thing that you should know about this council is that their meetings are in secret and nothing is published as to their deliberations or decisions. This is the Supreme Council of the European Union. Below that comes the Council of Ministers. This forum is attended by cabinet ministers of the various portfolios to represent those areas of activity. For example, the Home Secretary would attend this were it to be on law and order, and the Foreign Secretary on foreign policy, etc. This again is an extremely powerful forum. It has the ability to make laws and regulations and pass those laws and regulations down to the EU Commission for implementation. It can pass with those laws and regulations powers to implement them. And underpinning all their activity is the enlargement and the development of a European superstate, federalism. That is written into the treaties, that is their purpose. Below that comes the President of the European Union Commission. I can't tell you what the job specification is to become the President, or the selection process by which he was selected. But he was selected, and his name is Romano Prodi, and he is an Italian. Romano Prodi is worth listening to because what he says is invariably the truth. Let me give you some of the quotes from our President. He has said this, that he wants more power ceded to Brussels, particularly for foreign policy and defence, and this is happening. He says he wants the national veto, which was much vaunted by Harold Wilson back in 1975. He says he wants that abandoned, and it virtually has been abandoned. He has stated many times that there should be, and that there will be, a European army. And you must decide whether or not the Rapid Reaction Force, which has now been formed, is a fledgling European army. And during 2001, Prodi made a number of public addresses where he outlined his view of where the European Union should go. I'll give you just a couple of quotes. In February, in a State of the Union address to the EU Parliament, he said this, quote, "Are we all clear that we want to build something that can aspire to be a world power, not just a trading bloc, but a political entity, and that European citizenship should be a daily reality?" And then later in that year, in Paris, he said this, "The time has come for the EU to construct," and I quote now, "a fully fledged political union with the diplomatic reach of a world power, capable of asking its citizens what they are willing to die for together." Close quote. We seem to have moved a long way from that trading agreement. Romano Prodi is the president of the EU Commission. This is the third of the powerful forums that control the EU governmental structure. Each nation state is entitled to not less than one and not more than two commissioners. The commissioners are political appointments, and it is in the gift of the leaders of the nation states. In our case, we have two commissioners. We have Neil Kinnock, who was appointed by John Major, and we have Chris Patton, who was appointed by Tony Blair. They are appointed for 5 years, and they work on the European Commission, which, if you like, is the powerhouse that generates virtually all of the protocols, the regulations, the directives, and the laws that flow out of Brussels. They are there not to represent Britain or to represent the other countries. They are there to form a federal state of Europe. There are 20 commissioners currently in the European Commission, and each of those commissioners has been required to take an oath of allegiance to the European Union. As far as the British Commission is concerned, this is in direct conflict with the oath of allegiance they've already taken to Her Majesty the Queen. Below the Commission comes the European Parliament. Although it's called a parliament, it is not in our sense strictly a parliament as we know it. It has no powers to initiate or introduce new laws. In fact, it states in the treaties that the purpose of the European Parliament is to participate, and I quote there, in the processes of the European Union. Let me also tell you how it's described in the ABC of Community Law. It says this, "The European Parliament," and I quote now, "possesses only a few of the functions of a true parliamentary democracy. It does not elect a government. This is simply because no government in the normal sense exists at community level. The functions of government are performed by the Council of Ministers and the Commission." At the moment, there are 626 MEPs in the European Parliament. Britain has 87. As I've said, the Parliament has little influence or power. Each MP is usually allowed about 90 seconds to speak in any debate on any new legislation. So informed debate as we know it doesn't really exist in the European Parliament. But again, this is not strictly the problem caused by the MEPs themselves. The amount of legislation that pours out of Brussels is enormous. Let me give you some examples. By 1996, which was 5 or 6 years ago now, 1,916,808 pages of regulations and laws have been produced. Recently, the following directives and laws have appeared. For example, Directive 94/33 is on young workers and will probably destroy paperboy rounds in Britain. Wheelie bins, did you know, have now got to comply with EU standard EH840, and there is proposed EU legislation that will probably stop farmers' children from working on their parents' farm. Currently, there is a proposed vibration regulation restricting the hours one may sit on a tractor to 3 hours, drive a large lorry 6 hours, a dumper truck 2 hours, use a chainsaw 1.5 hours, a road drill 47 minutes, a brush cutter 15 minutes, and a stone cutter's hammer 3 minutes. These time limits will be gradually phased in during the next 2 or 3 years. This will give you some example, if you like, of the enormity faced by MEPs. The Lord's Prayer, as you probably know, runs to 56 words. God's 10 Commandments are 297 words. The Gettysburg Address is contained within 300 words. And the EU directive on the export of duck eggs runs to 26,911 words. The MEPs just haven't got a chance, so that most of the legislation that comes from the EU Commission goes through unopposed on the nod. For example, I was told last September by 2 MEPs that they were sitting in the European Parliament when they were required to debate and examine and vote on 187 pieces of legislation in 1 hour. And they did. They managed it. And they vote by pressing a green or a red button. So you can see that most legislation comes through totally unopposed and then comes straight to us in this country. Recently, in September 2001, Romano Prodi proposed that no longer would there be directives, but that there would be regulations formed in Brussels. The difference between regulations and directives is quite simple. Directives require the ratification by the home governments. Regulations require no such ratification, and as soon as they are made in Brussels, they instantly become law in the 15 nation states, bypassing national governments. And so you see the use of national governments is gradually dwindling. That is the European Union Parliament. Compare, if you will, the EU Parliament with the Westminster model. Under the Westminster model, there is a loyal opposition which challenges, questions and debates policy provided by the government. In the EU, there is no significant opposition. In the Westminster model, there is a Queen's speech setting out a programme of legislation for forthcoming terms. In the EU, there's no such announcement as the legislation. Most policy is decided in secret. At elections in our country, we've had policy manifestos from the various parties setting out the differing ways they would govern us. No such manifestos exist within the EU. There is one policy, namely federalism. In our Parliament, there are open debates and there are tight, accurate records kept of what is said in the House. In the EU, most governmental business is conducted in secret or in private. Finally, it is possible for the British electorate to vote in or out 100% of the government of this country. Not so in the EU. We are only able at the moment to vote for slightly less than 14% of the people who govern us. We have no control over the other 86%. We don't even know who most of them are. And by 2009, if the Nice Treaty is ratified and there is enlargement in the EU, we in this country will vote for slightly less than 10% of the people who will then govern us. And by that time, there will probably be no British MEPs, because all the MEPs will be pan-European. The state will have been formed, and so there will be no need for national candidates. And in addition to all that, all those people that I've told you who are in the EU governmental structure, and all the bureaucrats and civil servants that back them up, and there are thousands and thousands of those, all those people have a lifetime's immunity from prosecution for any acts or deeds done by them, and their buildings, their records, their archives cannot be entered, inspected, searched. They are above the law. It is written so in the treaties. That is the structure that now governs this country. So how is it that we've arrived at this situation? Quite simply, our politicians have signed a number of treaties, 5 in all. A rough description of British democracy is as follows. The power never leaves the people. Every 5 years, it is loaned by the people to politicians to govern them. At the end of that 5 years, it is returned to the people, and they decide whether those politicians or another bunch should govern us. The problem confronting the British has been that for the last 30 years or so, all the power hasn't been brought back. Some of it, as the years have gone on, has been signed away to others and not returned to the electorate. To date, 5 treaties have been negotiated, and as each treaty is ratified, more and more power has been transferred from national governments to the centralised government in Brussels. This is known as the Ratchet system, or the acquis communautaire. That which is acquired by the community is never returned. And so if power is transferred from a national government to Brussels, it is never returned. It is non-negotiable. Let us now look at those 5 treaties that have passed virtually all our national power to the European superstate. The first treaty, which we've mentioned already, was negotiated and signed in 1972 and was the Treaty of Rome. And to be fair to Edward Heath, if one reads the Treaty of Rome, you will see that all the detail concerning a fledgling superstate is in that treaty. As far as we were concerned in the United Kingdom, we did know at the time that we were signing up to the Common Agricultural Policy, the CAP, which meant that since 1972, our agricultural system in this country has been under the direct control of Brussels. What we didn't realise at the time, of course, was that as well as having an industry, the farmers husband the land that they work on. And this, of course, means that 90-odd% of the land mass of this country, which is arable farming land, came directly under the control of Brussels way back in 1972-73 and has been under their control ever since. We didn't realise that. One thing is also worthy of note is that in a white paper recently, in May of 2000, a government rural white paper, it opens with this following paragraph. The role of rural England as the food provider for the nation is no longer an essential one. One wonders whether that means that it is the intention to run down the farming industry in this country. I don't know, but I bring that to your attention. We knew about farming, but we weren't too sure about fishing. Because in order to get us into the then common market, Edward Heath signed away the rights to our territorial waters, which allowed other nation states to then use our waters to fish. We didn't know the significance of this at the time, because again, a number of papers were being suppressed. Can I read you just a few cabinet papers that have now surfaced under the 30-year rule? This is a Scottish Office memo of the 9th of November, released in 2000, and it's 2001, and it says that as the horrific implications of handing over our waters dawns on our MPs, ministers and civil servants should adopt a systematic policy of concealing what is happening. And it goes on to say it's vital not to get drawn into an explanation of what's going on or to admit what a disaster is in store for Britain's fishermen, who, in the wider context, must be regarded as expendable. Now, at the same time that these matters were being kept secret, Heath, in a government white paper to Parliament entitled Britain in Europe, was stating this, and I quote, "The government is determined to secure proper safeguards for the British fishing industry." And in December 71, Geoffrey Rippon, a then cabinet minister, told the Commons, "We retain full jurisdiction over our coastal waters." That was not correct. We were giving away our fishing rights to the other 14 nation states in the European Union. British fishing boats throw more fish back into the sea than they bring ashore, creating a huge pollution problem so as to comply with EU quotas. The whole common fisheries policy has been a disaster as far as our own fishing industry is concerned. You must decide whether or not that was a good or bad thing for us to do at that time. That all came about because we signed the Treaty of Rome and joined the then common market. The next treaty to be negotiated and signed was the Single European Act, and this was in February 1986. Even in this comparatively short space of time, things had moved on apace. No longer were we in the common market, we'd moved through the European Economic Community, and by this time we were in the European Community. Margaret Thatcher negotiated and signed this treaty, and she said at the time, and still does by the way, that she was tricked into signing it. This seems strange because in the very first paragraph it says that the purpose of this treaty is to bring about ever closer union. And indeed it did, because it introduced European influence into a wider area of activities, much more than trade. For example, it dealt with lawmaking, employment or working conditions, regional development, which is very current today, environmental issues and foreign policy. So we'd moved away from just a trading agreement with our continental partners into something which was much more political and constitutional. And perhaps most important of all, this treaty introduced the concept of qualified majority voting. Back in '75, we'd been reassured by Harold Wilson that our minister would always have a national veto that he could use if something was disadvantageous to the British. Qualified majority voting meant that there were certain areas of our life where we could no longer use the national veto. In 1986, there weren't too many areas, but as time has gone on under the acquis communautaire, more and more treaties have allowed the use of qualified majority voting. Until today, virtually everything in the European Union is decided by qualified majority voting. And the much vaunted national veto that reassured us back in 1975 virtually no longer exists. Romano Prodi is getting what he wants, the abandonment of the national veto. That all came in the Single European Act signed by Margaret Thatcher back in 1986. The third treaty was the now notorious Treaty of Maastricht, which was negotiated by John Major and signed in 1992. This introduced a whole raft of European influence into various areas of our life, and particularly introduced two very important policy lines, which we shall look at later. When this was being debated in the House of Commons, John Major made the now famous utterance that by signing this treaty, there would be no further surrender of sovereignty. Those were his precise words, no further surrender of sovereignty. And as soon as the treaty was signed, we in this country became European citizens, with the rights and privileges that thereby ensue, but also with the duties and obligations that would come with that citizenship. Those duties and obligations weren't defined, but they will be in the future. And we will know what is expected of us by being European citizens. In addition to citizenship, the treaty introduced EU involvement in a wide area of activity. The transport systems that we enjoy in this country are as a direct result of the Maastricht Treaty. For example, Title 4, Article 74 of the treaty develops a common transport policy, and this was initially mentioned in the Treaty of Rome. And it gave the Commission power to pursue any other appropriate measures. The present rail system, for example, in this country, where the track is owned by one privatised company and the rolling stock is owned by another or a number of other privatised companies, is as a direct result of compliance with a regulation within this treaty. It's a matter of interest, by the way, that we are the only country in the EU that has complied with that particular regulation. Recently, on the new maps of the road system of Europe, we have seen that there are new classifications for the road system in this country. Examples are, the M4 is now known as the E30 and runs from Cork through Rosslare, across to Wales, into London, up to Ipswich, across to Holland, through Berlin, and ends in Moscow. It is a pan-European motorway. And the M62, which runs across the Pennines, is now running from Liverpool to Leeds, as it always does, and then on to Lubeck, and is known as the E22. Air travel is now coming under direct control of the EU under their system of a single European sky. This means that in future, airports, the making of aircraft, and the running of various carriers will come under the direct control of the EU Parliament. And national carriers as such, it is intended, will be abandoned, and there will be one single European air carrier. All this dates from the Maastricht Treaty. Perhaps more importantly, Maastricht introduced the idea of the supremacy of the European courts and European legislation. Prior to Maastricht, the Supreme Court in this land was the House of Lords. That decided the eventual outcome of all cases. After Maastricht, that was not the case. Increasingly, more and more cases went from our own House of Lords across to Brussels to be decided in the European courts. And increasingly, European legislation took precedence over our domestic laws. A recent example of this, perhaps, is the metric mortar case, where a market trader was convicted of selling a pound of bananas using imperial measures. After the conviction, a judgment was given. And I'd like to read you some of that judgment, which will give you some idea of how far down the road we've moved to the supremacy of the European Court and European legislation. This is a judgment given by a British judge in a British court in 2001. And he said this, amongst other things. We are now living under a new legal order. The 1972 European Communities Act was a one-off, not an ordinary treaty, but a new way of life. These are new constitutional powers. The British Parliament surrendered its sovereignty in 1972. European Union laws have overriding force with priority over our British laws. And then he finished up by saying this: the articles on the supremacy of the British Parliament are now only of historical perspective. They are non-binding. Compare that judgment, if you will, with the utterances of Heath and Hailsham in the early 70s, who said that that particular Act of Parliament did not affect our sovereignty. We see now that since 1972, that sovereignty has been surrendered, and this judgment tells us that that is so. The Maastricht Treaty introduced the concept of European involvement in armed forces, and it said that there should be, and I quote here, an eventual framing of a common defence policy which in time might lead to a common defence. A common defence is an army. And already there's been set up a rapid reaction force which was initially set up to deal with operations outside of the European Union. Having been set up, we now find that it's been given powers to operate within the European Union. And although in this country it's described as the Rapid Reaction Force, Romano Prodi has said you can call it the Rapid Reaction Force, you can call it MAY if you like, but it is in fact the European Army. And that is what we're confronted with at the moment. Perhaps the most significant development brought about by the Maastricht Treaty was in connection with single currency. Although mentioned in the Treaty of Rome, the Maastricht Treaty established the introduction of a single currency for the EU. It specifically fixed a timetable for progressive stages to an economic and monetary union ending in, quotes, a single currency. Compare this, if you will, with the quotation by Harold Wilson in his pamphlet back in 1975 saying that we would not go into an EMU. We have been in a form of single currency before. In the early 90s, John Major took us into something known as the ERM, the exchange rate mechanism. This was where our own currency was tied in and locked in with EU currencies. It lasted for 23 months. And during that period of time, a number of things happened. British business suffered its worst recession in 60 years. 100,000 businesses went to the wall. Unemployment doubled to 3 million. There were more bankruptcies than in any previous two-year period. And it's estimated that Britain lost reserves of about 68 billion during that time. The reason for this was that we'd lost control of the levers of our economic policy. We couldn't respond to the vagaries of the economic markets. We had no control over our own economic policy at that time. The single currency is recognised on the continent as being a political initiative. For example, Romano Prodi has said, the roof of the EU superstate is on, the walls are going up, and the foundation is the euro. Otmar Issing, a co-director of the European Central Bank, has said that the euro is a political project in an economic wrapper. In Britain, of course, the significance, the constitutional significance of the single currency, EMU, has been consistently hidden from the public. If we were to join the single currency, we couldn't come out of it like we did with the ERM. It would be, in the words of the treaty, an irrevocable step, and we would be stuck with it if it didn't work. Because you see, by joining the single currency, we hand over all our gold and dollar reserves to the European Central Bank, apart from a small working balance. Economic control of the country moves from Westminster to Brussels, and constitutional and political power is handed completely to the European Union. We would, in fact, lose all power to Brussels by joining the single currency. It is that big a step. There are many figures as to the cost of converting all our systems to the euro. One figure I will quote is, it's been estimated that it will cost us 36.2 billion just to convert all the systems in this country from sterling to the euro. Those then briefly are the circumstances surrounding our entry, if it ever happens, into the euro. And this was signed up to in the Treaty of Maastricht. Perhaps the most important aspect that was introduced in the Treaty of Maastricht was the topic of regionalisation. During the early 90s, we were told there was a move towards devolved government in Scotland, Wales, Ulster, and eventually in London. And we were told that this was a devolution process taking place. But was it? In the EU, there are many areas that are now regionalised. In fact, the EU's full title is known as the European Union of the Regions, and at the moment there are 111 regions. It is the intention of the EU that our country will be regionalised as well, and that we will be turned into 12 separate regions. In each of these 12 regions there will be 3 EU structures set up, and already they have been so established. First of all, there is a regional government office for each of the 12 regions. Similarly, a regional development agency, where the people sitting on the agency are political appointments. And finally, each area has a regional chamber. 2 members of each of the 12 regional chambers regularly go across to meet at the Committee of the Regions in Brussels. The regions will in fact be answerable to and responsible to Brussels. And eventually, when these 3 structures kick in full, our own national government will be superfluous. We will have been regionalised, and we will have lost our national identity. That is the importance of regionalisation. Is it devolution, or is it EU regionalisation? Tony Blair negotiated and signed the Amsterdam Treaty, which together with the Treaty of Maastricht became known as the Consolidated Treaty. Again, this was a very important treaty, even though Blair said that it was just an amending treaty. There were a number of facets which affected us greatly. First of all, as soon as that treaty was signed, our own government lost its ability to give assistance to its own citizenry in times of crisis. For example, in the foot and mouth disorder that we recently experienced, it is the decision of the EU whether or not farmers will be compensated and by how much. In other words, it is no longer in the gift of our own government to give aid and assistance to its own citizenry, because this, to quote the treaty, would distort the workings of the common market. It is now in the gift of the EU, not in the gift of national governments, to give aid and assistance. That we signed up to in this particular treaty. We also signed up to something known as Europol. Before this treaty, each nation state had its own domestic police force, which could operate within the confines of that domestic state. Europol is a federal police force, which means that the officers within Europol can exercise their duties pan-European without the need for extradition process. And of course, this will involve the introduction of a Euro prosecutor exercising Euro laws. And the Euro police, as they are servants of the EU, will have a lifetime's immunity from prosecution for any acts or deeds done by them, and their offices and buildings and archives cannot be inspected or searched. Under Article 29 of this treaty, and for the very first time in our history, the power to adopt laws to combat racism and xenophobia were defined. But the treaty failed to define either of those 2 terms. And in addition, the treaty also gave the EU power to adopt decisions for any other purpose consistent with the objectives. On the 6th of March 2001, the European Court of Justice ruled that the EU can lawfully suppress political criticism of its institutions and its leading figures. This was in the case brought against Bernard Connolly, who was sacked as an EU civil service servant after writing the 1995 book, The Rotten Heart of Europe. This ruling by the court resurrects the offence of seditious libel, which has been banned by the British House of Lords. It also goes directly against the non-EU Court of Human Rights at Strasbourg, which has repeatedly stated that governing bodies may not restrict criticism in such a way. So, for the very first time in our history, freedom of speech has been defined and limited by the EU. There were 2 other areas of interest in the Amsterdam Treaty. One concerned taxes, where it stated within the treaty that taxes must be harmonised across the whole of the EU. That will happen, and it will apply to this country as well as the 14 other countries of the EU. And finally, directives and regulations have been produced by the EU which concern and will affect the working of our financial markets and the stock markets of this country. So we see that the amending treaty, so described by Tony Blair, of Amsterdam, again is making serious changes to the way we live in this country. In December 2000, Tony Blair and Robin Cook returned to Britain, having been at Nice to negotiate the Treaty of Nice. They stated that it had been a triumph for Britain, but failed to mention that there were 30 more areas of our lives where the national veto had been abandoned. But there were other equally important areas that had been decided at Nice. For example, the establishment of Eurojust. This is a pan-European form of prosecutor who will be able to prosecute offences across the whole of Europe. But of course, by signing up to Eurojust, we also signed up to a pan-European system of criminal law, and that will undoubtedly be corpus juris. Corpus juris, if you like, is the Napoleonic form of criminal justice. And in our form of justice in this country, we've always tried to balance the imbalance between the individual and the state, and a number of principles have protected the individual. The three main principles are, first of all, the presumption that we are all innocent until proven guilty, presumption of innocence. Secondly, habeas corpus, which means we cannot be kept in custody for more than 96 hours unless we've been charged with a serious criminal offence. And finally, every one of us in this land is entitled to trial by jury. If we adopt, and we probably shall, corpus juris, those three main principles that protect the individual from the state will be abandoned. There will be no habeas corpus, there will be no trial by jury, and there will be no presumption of innocence. And already we've seen around the land magistrates' courts being closed because that system of justice will soon be abandoned. And similarly, we've also seen efforts made to bring about trial without jury. In December 2001, the British government, in trying to push through the terrorism bill in response to the 11th of September acts in America, was in fact introducing the main principles of corpus juris to this country. The Nice Treaty introduced other restrictions on the way we live. Under Article 191, the treaty states that political parties at European level are important for integration. They contribute to forming a European awareness. The Council shall lay down the regulations governing political parties and in particular their funding. What this means is that Article 191 grants the EU power to withdraw or prevent funding of political parties they deem unsuitable. In effect, the EU will decide on the opinions of and the conduct of political parties by controlling their funding. There are many other facets to the treaty, but one final thing I would mention, and it concerns our human rights, things that we have taken for granted for centuries. Within the Nice Treaty, the EU laid down a proposed Charter of Human Rights. However, Article 52 of the EU Charter states this, that, quotes, the EU may limit all rights and freedoms enumerated in that Charter where necessary in order to meet objectives of general interest recognised by the EU. This means that for the very first time in our existence, our human rights can be defined and withdrawn by the state, something that could never have happened in this country before. Those then are the 5 treaties that have been signed during the last 30 years and have brought about the present set of circumstances. You may recall in '72 we were told we were joining a common market. Today, the European Union has 300 million European citizens. It has European borders and a European Parliament. It has its own civil service and flag and a European anthem. There is a European central bank and a European currency. Now there is a European foreign policy and European army to back it up, with European laws and European courts that are assisted by a European system of justice, European police, and a European prosecution system, and a pan-European transport system. Coming soon, there will be a European constitution and a European-wide tax system. Are we looking at a common market, or are we looking at the birth of a European federal superstate? And what has this cost us, membership of the EU, over the years? It is estimated that with the balance of payments deficit that we've enjoyed, the amount of money that we part with each year to the EU, and the cost of compliance with EU regulations, it has cost us many hundreds of billions of pounds to be members of the EU. Our current annual contribution, our cash contribution to the EU, is just in excess of 11 billions. And that works out to £1.25 million every hour of every day that we hand over to the EU. Or put it another way, every constituency in this land has to find £300,000 every week of every month of every year to pay to the EU because we are members of the European Union. Fraud and corruption are endemic in the EU, they themselves admit it. In 1994, the EU Court of Auditors was formed in order to examine the books of account of the EU, which had not been examined for the years prior to that. Since that date, the EU's own Court of Auditors have refused to sign the books of account for the EU because of fraud and irregularity. In the year 2000, the EU estimate that they lost £4 billion in fraud and corruption. That is the official estimate. The unofficial estimate is double that. So, is there any alternative to membership of the EU? Of course there is. We can withdraw. There is no inevitability about our membership of this club. After all, none of us in Britain have ever been asked, do we wish to join the European Union? And for that matter, none of the peoples of Europe have ever been asked that question. This is purely a political project, and there is no inevitability about it. We can, if we wish, withdraw. And if we did, would there be any major loss of jobs to Britain? No, there wouldn't be. We buy more from the EU than they buy from us, so trade would continue, as it does with the rest of the world. There will be no trade barriers and no loss of markets. Constitutionally, are we able to do this? Yes, under our present constitution, no incoming government is bound by the decisions of a previous administration. Therefore, if it was the will of the people and the will of our government that we should withdraw from the EU, we could do it like that. And economically, it would make good sense too. We are the fourth largest economy in the world. Therefore, if we can't exist on our own, who can? And what would happen if we did leave? We would regain all those areas of our life over which we've now lost control. Our fishing and our farming would be ours to decide upon. Our courts, our armed forces and our police would again come under our control. Our democracy would be established and strengthened. Our citizenship would return. We would be British again, not European. And perhaps the most important thing of all, we would regain our own government, the ability to govern ourselves and our own country in the way we wish to be governed. All those things can happen if we withdraw from the European Union. Can I leave you with 4 quotations from politicians that I think are pertinent to this particular question? First of all, William Gladstone in 1891 said this: "If the House of Commons by any possibility lose the power of the control of the grants of public money, depend on it, your very liberty will be worth very little in comparison." Lord Stoddart summed up Britain's involvement in the EU thus. He said, quote, "Britain has given self-government to all its former colonies, yet the people who support that policy are the very ones who now deny that Britain can survive as an independent self-governing nation. What nonsense," he says, "what absurdity." Tony Blair in 1982 and 83 said this: "Above all, the EEC takes away Britain's freedom to follow the economic policies we need. We will negotiate withdrawal from the EEC, which has drained our natural resources and destroyed our jobs." And finally, Edward Heath in 1971 said this: "There is no question of Britain losing essential national sovereignty." If you're in favour of Britain's membership of the EU, there are a number of organisations which support that membership. If, on the other hand, you are in favour of Britain being a self-governing, independent nation, there are also a number of other organisations which support that view.